I'm Ronald Thwaites. I've been practicing law in Jamaica for over 50 years. And I'm happy to have these conversations with you about legal matters that concern everybody's lives, whether you live in Jamaica or you live abroad. Now, please remember, this is not a substitute for consulting your own lawyer if you have a particular issue or problem. Listen up.
What is the difference between registered and unregistered land?
The difference is certainty and uncertainty. Let me explain. When you have a registered title for your land, the expression in law is that that title is good against the world. That means nobody can challenge your ownership of it. A common law entitlement, a common law title, is somewhat more uncertain because that means that you have a document, but that document may give you certain rights, but it is a halfway house. And in this modern world where land is used to secure financing, it is used for a variety of different purposes, you shouldn't settle for anything less than a registered title.
What is the value of a registered title?
The value of a registered title is that it can be transferred, it can be mortgaged, it can be willed very easily. If you don't have a registered title, your tenure over a piece of land, a piece of property, is going to require more work. Lawyers benefit more than clients when land is unregistered.
What circumstances make me qualify to get a title for land?
That you can establish ownership. Now, you may have bought a piece of land, you may have inherited a piece of land, and I can tell you there are certain circumstances in which if you live on a piece of land or use a piece of land exclusively for a long period of time, then you can apply for a registered title. Or you may be in the position where you are holding property for someone who is underaged or someone who is elderly and can't manage. In those cases, your registration can be grounded for that particular piece. Here's the law. If you have been in, listen now, undisturbed possession of a piece of land, nobody come and say, you know, I really own it, you're just scratching here, or I'm giving you a tenancy. No, you're undisturbed for a period in excess of 12 years. You may apply to be registered as the owner of the land, even if there is a registered title to it. So what does that say? Owners of land, don't think that because you have a title or because you have a common law paper, you can just put it down and you're undisputed for the rest of eternity. You must go on your land and own the land, put a fence up, do something with it, even in order to prevent anyone else coming and establishing rights by what is called adverse possession.
If I pay up the land tax for a few years, am I entitled to get a title?
No, and this is such a common mistake. People feel that I've been paying the land tax and so I must be the owner. It is one feature that leads you towards ownership. But I can pay tax on your land until the Lord comes, and it can still be your land. So that's not good enough. You need to submit a certificate of payment of taxes to get a registered title, but it doesn't prove automatically that you're the owner without more.
What information do I need to apply for a registered title?
First of all, there's a form that you have to fill out as the applicant. Secondly, you have to have a survey which delineates the exact boundaries of the land. And since we are now building on very small portions of land, and also in cases of family land where boundaries are fluid within a group of people, a survey is very important. And even if you had a survey, or if there was a survey in the past, it's good to get it upgraded if it's more than 5 or 7 years old. Then here now, you're going to need what are called declarations from 2 persons who know the history of the land. Big people, people of age, who can say that I know that Miss Matty owned this land and she passed it on to so-and-so, and that here is the evidence of that. And those are the main things that you're going to require in order to ground an application to register.